call the second case on this morning's docket. It's case number 113580, State of Kansas v. Jack LaPointe. Counsel, if you could give a minute for us.
Yes, sir.
Please proceed.
Thank you, Your Honor. Mr. Chief Justice, may it please the court, Richard Ney appearing for the appellant in this matter, Jack LaPointe. Mr. Chief Justice, I would ask for 3 minutes for rebuttal.
3 minutes is granted.
Thank you. Your Honors, Jack LaPointe was convicted of the armed robbery of a Payless shoe store in Roland Park, Kansas. He was sentenced to a term of close to 25 years. His conviction was based on two witnesses. An eyewitness who claimed to be able to identify the robber while she was in a moving vehicle in a dark parking lot. And an informant who testified against Jack for a grant of immunity for the same robbery. The evidence recovered nearby the scene included a bandana, money dropped by the robber. There was no contest about that. And the bandana contained human hairs. After years of litigation with the Johnson County District Attorney's Office, the defense was able finally to test the hairs from the robber, and they were not Jack LaPointe's. We are asking for a new trial based on this exonerating evidence.
Counsel, to be precise, and I want to make sure I get this right, what was tested were two hairs, correct?
Yes, Your Honor.
And one came back inconclusive.
Based on the degradation of the
Regardless,
sample.
it came back inconclusive, which was consistent with what was said during the original trial, that it was inconclusive and the hair was probably not Mr. LaPointe's. The one test you got that was conclusively not his was one hair, correct?
Yes,
Okay, so we're talking about one hair.
we are.
Okay.
How does this change the evidence for a new trial? I mean, wasn't the initial trial included expert testimony that the hairs found that were collected off of the evidence that was found near the scene were not likely to be your client's hair? In fact, and wasn't that a part of the evidence that the jury considered was these hairs are not likely his?
Well, likely.
And won't that be the same evidence that's produced at trial the second time? How's it going to differ?
Well, the hair is definitively, by mitochondrial DNA, not Jack LaPointe's.
And isn't that essentially what they heard at the first trial?
No. Criminalist Booth, who testified for the state, said, probably not, but...
A little more than that.
Well, let's see what he said. They could actually be his hair. That's a quote. Could actually be his hair. And he gave some examples. He said because they only had a representative sample of the defendant's hair, it's possible that one of the defendant's hair could be matched to one of the unknown hairs. And the second explanation was that after the hairs on the clothing were deposited, and it was some time until Jack's arrest, the defendant changed the way he maintained his hair. Then he went on to say the defendant's hair was similar to the hairs found at the scene, that they're very light and fine in diameter and very light in pigment. Says there was a little difference in their consistency. One was rough, one wasn't. But if we say that the jury accepted that these were not Jack's hair, we've got a real problem. Because Booth also testified and said that the hairs found in the bandana were almost assuredly from the person who last wore it, which was the robber. There was no contest to that. The state argued that the bandana was worn by the robber. That's in their closing argument in this matter. They said that the dogs tracked the robber to that location. They were all picked up by the dog. Those were the items that were involved in this, talking about the bandana, the money, etc. So we have a bandana containing hairs, which the state is saying this is the bandana. It's worn by the robber. The robber was the last person to wear it. Therefore, under Boo's testimony, the hairs came from the robber. And are we saying that the jury said, well, that's the bandana's from the robbery, the hairs are from the robber, they're not Jack LaPointe's, but we're going to convict him anyway? The jury had to accept one of Boo's exceptions to convict him. Otherwise, they said, yeah, robber's hair doesn't match Jack, not Jack's, but we'll convict him for the heck of it.
Isn't there a little wiggle in there? If the testimony was the hair was most likely deposited by the last wearer, but not that it was definitely, I mean, doesn't that have some impact? Because that's your main premise, right? That they had to have been left by the last person to wear the items.
And that was the state's testimony. Right.
Not that they had to have been, but they were likely to have been.
All right. Yes.
Okay. I mean, that's where you've got a little sand under you, right?
I would say a very little, but a little.
Okay. All right.
So when we look at the conviction, was based on an eyewitness who again, under those circumstances, driving through the parking lot, sees somebody. She picks out Jack. But let's remember the other eyewitness. That's Miss Lovell. Miss Wellman testifies. She's the store clerk, by the way, who has the gun put in her face and sees the robber, says, it's not Jack. She says she picks out a photo of someone else, Mr. Sieber. Now, the Court of Appeals, when it looked at this case, on the first appeal of the 1507 we filed, turned to that identification. And the reason the jury, they said, and we would agree, went with Lovell's identification for the parking lot was the incredibly improper vouching that was done by the police officer. The Court of Appeals, in quoting from their opinion in 2009, said, Atwell's, that's the police officer's, testimony about the reliability of Lovell's eyewitness identification of LaPointe over Wellman's eyewitness identification of Sieber became the crucial basis, if not the main basis, for LaPointe's conviction. So we have a conviction based on a fairly weak eyewitness identification that the Court of Appeals said only made it and made the case because Atwell is allowed to say, and here's what he said, I have much more confidence in Miss Lovell's identification than in Miss Wellman's.
And counsel, in all this back and forth about the evidence, and regardless of how it might have been argued to the jury, the district court disagreed with your arguments in terms of whether this would have affected the outcome of the trial. Our standard of review is what?
Well, deference to that
Abuse
opinion.
of discretion.
Right.
It's got three elements. Which one are you arguing the district court violated?
Well, I think it's definitely abuse of discretion.
Well, but
Well,
there can be three ways you can abuse discretion. Is that no reasonable person would look at this case and come up with the same conclusion that Judge Moriarty came up with. Is that what you're arguing?
I am. And Judge Moriarty made a fairly inconsistent ruling. He said when we asked for the hairs that it's material and could change the trial, could be exonerating. That was his ruling when he ordered that we were finally allowed to get the hairs to test. They came up, as we consider them, aces for us. And then he says, but it doesn't matter. And the reason he says that, if you read his opinion, is because of the snitch, Mr. Norton, and the eyewitness identification. Now, we all know what the two prongs, or two of the major prongs, of convictions, erroneous convictions are. Bad eyewitnesses or misidentification by eyewitnesses and snitch testimony. So what is the point of the DNA testing? Ever, in any case, we're going to say, well, there was evidence to convict him. Obviously, there was evidence to convict anybody who's convicted, or we'd be here on a different kind of motion.
Counsel, let's go to the threshold question. Why is your client entitled to this testing?
Well, he's entitled to this testing, number one, and I would say it's our argument at baseline, that's irrelevant to our claim. Because we have the testing. Are we just going to ignore it now? Say, well, yes, he's innocent, but too bad you shouldn't have gotten it. I think that's water under the bridge. But if you're asking a hypothetical defendant in Jack LaPointe's situation, he's innocent. That's why he's entitled to it. I don't care, frankly, if this is a charge of murder or rape or aggravated robbery where you get 25 years in prison. You know, why isn't someone allowed to do that? Judge Moriarty, we submit, under the DNA statute, but also under his own authority as a judge, the inherent authority of the court to order this kind of testing.
Counsel, can I ask a follow-up question to
Yes.
the Chief's question, which is slightly different? I appreciate your answer about he's entitled to the testing, we already have it. A variation of that is, why is your client entitled to the procedures outlined in KSA 21-2512? And isn't that the procedures that you're following, that you're proceeding under that statute?
It is, Your Honor.
So that's different from the testing. Why is your client entitled to take advantage of those procedures?
I think as we
I
argued
guess
in our
I-
brief, if this court has expanded that statute. Obviously, if we were just talking about that statute, there are several cases that the court ruled on erroneously. We don't believe so. The state is arguing you did. We think that's correct.
So what's
But
your
there's-
best? Go ahead.
I'll interrupt because I was going to follow up with him with the question you ultimately asked. We have not expanded our decision, not even Cheeks went that far, correct? To look at aggravated robbery as a basis for getting testing under this post-conviction DNA
Correct. But
statute. So you're asking us to go beyond Cheeks.
well, Cheeks really talks about the amount of time an individual got, how these are alike. This isn't a trespassing charge or a DUI where my client got 6 months in jail. He got 25 years, which he just started serving 2 years ago, by the way, because he was in federal custody. So he is sitting there under a significant sentence. Frankly, not a lot different than the cases this court has ruled on. So are we really talking the distinction between crimes or the severity of the erroneous conviction?
Well, the statute doesn't go into that, does it? It talks about 2 specific crimes, as I recall.
Right, and this court has expanded that, and the legislature has had the opportunity to speak if it wanted to, and it hasn't. And obviously it's accepted this court's position on that. We think for this statute to be constitutional, frankly, that anyone with a significant sentence should have the right to prove his innocence.
And you basically get that from the majority's conclusion in Cheeks, is that this is driven by the length of the deprivation of liberty as opposed to the particular crimes, even though the statute points to specific crimes.
Yes, we do.
And the majority of this court said that, yes, that's correct. So basically, anyone sitting in state custody with 20 or 20, I don't know where the line is, because any time is significant. But if you're talking about 20 or 25 years, if they can prove, if they can demonstrate DNA would be part of their case, they should be allowed under the statute to proceed.
Absolutely.
And that's basically your point. And so, Mr. LaPointe, Cheeks, anyone who's similarly situated can avail themselves of this procedure.
That's our submission. In fact, we would submit that even the statute didn't exist. If I had a client who was in for burglary for 20 years, and I could come before a court and say, look, this conclusively proves he's innocent, Are we really going to be so deaf in the justice system to say, we don't care, we're not going to listen to this?
But that's really a policy argument, not an equal protection argument.
Well, I think, well, that's a policy argument, but it becomes an equal protection argument when we say some people will get relief and some won't. I mean, we had an anomaly in this, and there was an actual defendant that I'm aware of who was charged with first-degree murder, was convicted of second-degree murder on a lesser charge, then wanted to do DNA, and the prosecution said, well, sorry, you should have been convicted of the original charge, and then you'd have the right in the same case.
We're talking about this. Where does it stand in this procedurally in this case? You said, yeah, we can't ignore the testing now that it's been completed, but is this an issue that's before us now since it's kind of past that point?
No, we argue it isn't. We argue the Court of Appeals never reached this in the opinion below. We argue, frankly, that doesn't make this a judiciable issue for this court. The state took an appeal, took a petition for review from that, but there was no ruling. So I'm not sure what we're reviewing here, number one.
So is it where is I'm trying to figure out how to word it. The reason your client, Mr. LaPointe, has as severe a sentence as he has is not because of the crime he committed, but because of his unsuccessful, extensive career as a criminal, right?
Well, the sentence would be severe.
And so are we in a position where if you're have a long criminal history, you get DNA testing because your sentence happens to be as severe as some of the qualifying crimes, but those who are not successful, or those who do not have a long criminal history and commit ag robbery, don't get DNA tested?
Well, frankly, Your Honor, if I were here with someone who had gotten 10 years, I'd be arguing the same thing.
But what's the equal protection argument that lets you look at the defendant's characteristics, criminal characteristics, and create a different classification than what the statute creates?
Well, the statute created those differences. I don't understand them from the beginning. I think an innocent person is an innocent person, and it's an abhorrence to justice to allow an innocent person to remain in prison and just say, well, you're only there for 20 years.
So your argument under equal protection is that innocent people that are incarcerated are similarly situated persons. That's your argument.
That's my argument. Frankly, I don't care if it's 25 years or 25 months or 25 days. Really, are we going to be deaf, dumb, and blind to innocence? We've seen that happen in this state. And if Floyd Bledsoe, for example, clear example, had been convicted of something less, is it okay he sits in prison, an innocent man, for another 20 years? It's not. And that's the point. But Judge Moriarty took his authority, we believe, under the court, to have this tested. Whose evidence is this anyway? It's not the state doesn't own it. The court has control over it. If the state wanted to destroy it, for example, they'd have to make a motion to the court. Is not the court in control of this? And then once that evidence is produced, then there must be a remedy under the law to free innocent people. That certainly is a constitutional protection.
Well, the remedy you're seeking, as I understand it, is not to set your client free, because this ultimately disposes of the question of guilt or innocence, but to send it back for a judicial determination.
Yes, Your Honor.
Based on all the evidence that came in at trial.
Yes, Your Honor.
Do we have any further questions? Thank you, counsel.
Thank you, Your Honor.
Mr. Chief Justice, and may it please the court. I'm Jacob Gonteski. I represent the plaintiff, the appellee, the cross appellant in this case, the state of Kansas.
Counsel,
Yes.
why shouldn't a person who insists upon his innocence get an opportunity for a new trial under these circumstances?
He shouldn't, because the right to post-conviction DNA testing is not a constitutional right. It's a right vested in certain persons by the legislature across the street. It is their purview to determine, as a policy decision, who is entitled to such testing. And the political machines, the political machinations that go on across the street can put pressure on the legislature to expand that statute and make this remedy available to a wider array of defendants, but it hasn't done so. It didn't do so when it created this statute, and it hasn't since. This defendant was not similarly situated to Cheeks or Denny or those that are under the strict reading of the statute. He wasn't similarly situated, he isn't now, because he didn't receive a sentence that was on par with those. All of those cases involve sentences that are life sentences. This does not. This is not an off-grid offense. As was already noted, Mr. LaPointe received what was a relatively harsh sentence, not because aggravated robbery is as severe of a crime as rape or murder, but by virtue of his unsuccessful criminal past as a criminal history A. That's what landed him in prison for as long as it did. Had a rookie committed this offense with him in 2000 and been convicted, he'd already have been out of prison for 10 years or more by now. He would have received a sentence of 4 or 5 years. He'd be out long ago. Mr. LaPointe would almost be done with his sentence in this case now if it were not for other sentences that he had to serve elsewhere before he could come and complete this one. So because post-conviction, after conviction, defendants have markedly lower rights to this type of claim in court when a jury has already determined their guilt. That's what occurred here. He was convicted, and he was not convicted on erroneous DNA evidence. He wasn't convicted on anything that even conflicted with this evidence. This evidence, as was noted earlier at the outset of today's argument, this evidence is very much on par with exactly what the jury already heard. The state presented evidence that hairs were recovered from this clothing. The hair that was recovered from this clothing was not consistent with Mr. LaPointe. The state's own expert testified as much. The state's own expert could not absolutely conclusively determine it was not Mr. LaPointe's, but he said the characteristics of it are not consistent with Mr. LaPointe's hair. He testified that he had several representative samples of Mr. LaPointe's hair from the back, sides, and front of his head, different types of hair from different places. He put those under slides and compared it to the hairs that were found on the clothing. They were not consistent. He was pressed and he said, I cannot say with absolute certainty that they're not his, but I don't see it. I don't believe they were his hairs. That's precisely what Mr. LaPointe's expert would come in and say now. The DNA did not prove that the 2 hairs found on the bandana or cap were not Mr. LaPointe's. That testing proved that one of them was not his hair, but the other one was inconclusive. When you read the report that came back from Mr. LaPointe's expert, he first submitted 1 hair to his own expert several years ago. That first hair with the identification number that ends in Q1. In August of 2014, Mr. LaPointe's expert came back and said the results are, quote, inconclusive with respect to Jack LaPointe. He and his relatives can be neither included nor excluded. Later on, that report goes on to say they think it is more likely that Mr. LaPointe could be excluded than included, but it could not be said with certainty. That report is almost identical to what Mr. Booth testified in this trial. This would not have changed the outcome one bit. So I'm trying to answer both issues when I answer your question. Because first of all, the motion for new trial was properly denied because the jury already essentially heard this same information and determined his guilt. As to why Mr. LaPointe was not entitled to this testing in the first place and was thus not entitled to the procedure that's outlined in 21-25-12 is because the legislature said so. when the legislature designed this statute. The legislature could have said, we're not going to write this statute. We're not going to make this post-conviction DNA testing available. But they
Let's
did.
say that's the case. Could a convicted person come to a district court and ask for DNA material to be tested?
I don't see why not.
So you would not contest that it would be, a district court would have the discretion to allow that absent the statute?
Correct.
But the testing would be then the responsibility of the defendant?
Correct. And although in this case, Mr. LaPointe did pay for his testing, the statute doesn't contemplate as much. The statute is in place for defendants regardless of their ability to pay. And that statute was narrow in scope and debates were had. This court in Cheeks discussed the debates that were had across 10th Avenue about the scope of the statute. And those debates that were had determined the statute would be narrowed to defendants convicted of murder and rape. Those are defendants that are given life sentences. And whether that narrow scope was as a result of economic decisions or the belief that some crimes are more susceptible to exonerating evidence through DNA, as was noted in several of this group's dissents in Cheeks, or whether or not it was out of a desire to first experiment with this approach with a small class of offenses. Whatever the rationale was, that was within the purview of the legislature. That is what they are in place to decide, not us, not this group. And so because that remedy was not available to him, this testing never should have been done in the first place under this procedure.
What do we do with your argument and that issue now that the testing's been done? Do we address it? Do we not address it? Wait for another case? What do we do with it?
I hope you do address it. I hope you do address it, and it's properly here because the state petitioned so as a question reserved. The state did so previously. It was argued here before on a question reserved. But at that time, there were still ongoing hearings at the Court of Appeals on other aspects of the case. So this court declined to entertain that question reserved because the case wasn't final. The case is final.
So then what do we do with it if, let's say we agree with you, that's just for argument's sake, what happens with the testing that has already been completed?
Nothing happens with that testing. That testing is already here. We already have it. I'm already arguing that the motion for new trial was properly denied. That should stand. Judge Moriarty's order and the Court of Appeals affirming his order that the motion for new trial was properly denied should stand. That should remain in place. But this court can and should go on to say that it is not going to bless further expansion of the statute beyond even what Cheeks said to this group of defendants, which would be, I don't know what it would be. Would it be those convicted of a sentence of 247 months or more? Is that what would make it available to him? Or is this court in a position to bless it for all defendants, as Mr. Ney argues now? Or is it those convicted of level 3 and above? Where's the line? That line should be drawn across the street. That is the group that decides that line. If this was a constitutional right, we would have a different argument here. The United States Supreme Court has said DNA testing post-conviction is not a constitutional right that defendants in custody have. That's why it's within the purview of the legislature. That's why there's not an equal protection violation here.
Counsel, I'm sorry, finish your...
That's why this body should not be in a position to delineate who gets the testing and who does not.
I wanted to go back to Justice Rosen's question and make sure I understand this. If the court said Mr. LaPointe was not entitled to this testing, we buy your argument there, does the inquiry then end?
The inquiry as to this case?
Yes, because your answer to him, I think, went further to say, well, we would still have to be reviewing Judge Moriarty's decision, and if we agree with your position on that issue, then we're done. So my question is, what if we just say there was no right?
I think you could still say there was no right and still address Judge Moriarty's position on the motion for new trial. That's what I would ask you to do.
And what if we disagreed with your argument on that issue and said, no, even though there was no right to this testing, it's been performed, we disagree with Judge Moriarty, he abused his discretion, it's going back. Is that a scenario that you can address?
That he was not entitled to this testing, but because it was done, the motion for new trial, if you find, was improperly denied and it should be remanded for a new trial?
Yes. Is that a scenario?
Is that a scenario within your power to decide or to play out?
Well, this is in two pieces. The testing was done. Let's just assume for argument's sake he was not entitled to it. But we have the results. And my understanding is you're saying even with these results, Judge Moriarty was right. It's not going to make any difference, so we're done. What if we disagreed with you on Judge Moriarty's ruling and said, no, it does have an impact, or could, so then where we are, can we do that?
I believe you could, but I would hope that at the same time you would say prospectively, you could decide that the confines of 21-25-12, this court could decide should not be expanded beyond Cheeks. And although it was already done here, we're not going to ignore those results, and so we're going to pay attention to them and address on the merits the motion for new trial. I believe you could do that while still deciding prospectively our district courts are not in a position to expand at their will the statute or expand it even beyond Cheeks.
Which is the nature of a question reserved.
And that's precisely why we appealed on that basis.
Right.
And
In other words, the remedy's just limited to this case. If we disagree with Judge Moriarty, the remedy's limited to this case.
Correct.
That would be your position.
And I would hope that you would address on the merits
I understand.
the state's cross petition.
And see, I was trying to wrestle with looking at this like an objection with a preservation issue, you know, and we, as many times as we've tagged the state for not cross-appealing on the Court of Appeals ruling that it's preserved, but we're going to go ahead, and then you guys want to get ahead of it. I was trying to figure out whether this is one of those situations where it's just sort of a bucket of issues, and we reorder the issues however makes logical sense, which on an evidentiary question with preservation, you might go to the preservation thing and say, oh, the state's right on its cross-appeal about the preservation, so we don't have to get to the merits. And I thought it was kind of tricky the way you guys postured this case, because your notice of appeal sort of puts every statute known to Kansas as to a right of appeal.
And I can explain that.
Right, and I can kind of understand why you do that, given the many times you're up and down. My point is, as we stand here today, as you stand here today, you're willing to have us proceed as if this is like a question reserved, and deal with the defendant's question, and deal with your question, and however that shakes out, call it good.
Precisely.
Okay.
The rationale behind both citing to the question reserved portion of the statute that allows the state to appeal, as well as some civil provisions, is that this court in the past has discussed petitions that are filed under 21-25-12 as being criminal in nature. This one was filed within a criminal case, but that those motions done under 21-25-12 could also be done in a civil context under a 1507, for instance. And so to ensure that the issue was addressed of the scope of 21-25-12, the state wanted to ensure it was preserving it under a question reserved, or however this court wanted to look at it, as a civil appeal or as a question reserved on the criminal case.
And if we went that way, that lets you avoid the defendant's argument that the state is limited on the issues that it can ever appeal, regardless of whether it's a cross appeal or a regular appeal.
Correct.
Okay.
Correct.
And just so I understand the scope of your, what we're calling question reserved, is I mean, you've said several times, don't expand Cheeks. I understood the scope of your question reserved to be broader than that. Am I
agree.
right about that?
You are. The scope
You're
of our-
asking us to overrule Cheeks.
Absolutely, I am. Cheeks should be overruled, and we should return to the express written statement of the legislature. There's no ambiguity there. There's no vagueness in this statute. No claim has even been made as of such. Only the equal protection claim has been made. Respectful of your time, I realize I'm out, but I'm happy to entertain any further questions this court may have.
Does that otherwise conclude your presentation?
It does. What I'm asking this court to do is to find Judge Moriarty did not err in denying the motion for new trial, and furthermore to find that the trial court did err in the first instance in granting this testing. Cheeks should be overruled, and we should return to the statute as it was written by the legislature.
Any more questions? Thank you, counsel.
Thank you.
May it please the court. We certainly take exception with the argument that there's just no right to get DNA evidence. The Supreme Court has never said so. They certainly have. In our reply, or in our reply to supplemental brief of the appellee, which we filed with this court, we cited Skinner versus Schweitzer, United States Supreme Court case from 2011. It was a 42 U.S.C. 1983 claim, and the court said that based on due process rights, a state defendant had a right to ask for DNA, for samples to do DNA testing. And I think the state has conceded here that Judge Moriarty could recognize that right, as we submit he did, and grant this testing over and above the DNA statute. Now, the state says, well, their witness was called to exonerate our client. The prosecution called Mr. Booth to exonerate him. Well, that's not true. He was put on, and here's the testimony. It's cited on pages 17 and 18 of our brief. The prosecutor asked, does that mean we can say with certainty that those head hairs obviously cannot have come from Jack LaPointe? Answer, directly, no. But the probability is it's not his hair, but there is some remote explanation that he could actually be the source of the hair. It goes on. When he's asked what that explanation mean is, the Booth, the expert, says it's quite possible I may not see a hair on his head that could have matched. Quite possible. He says, again, as we quoted, the possibilities. So we can't accept the fact that the jury heard this and said, yeah, it's not Jack's hair, but it's the robber's hair, and we're going to convict him anyway. If we look at this court's decision in George, which we cited by 609 letter to the court, that handed down in June, which dealt with hair evidence, certainly this hair evidence is much more exonerating than the possibility of George's hair evidence in that case. Your Honors, we look at this situation as the state argues this. They're basically telling you this, if this makes sense in a reasonable world. If the robber, whoever he was, because I submit it wasn't Jack LaPointe, had shot Miss Wellman, the clerk, and she died there on the floor, no problem. Same case, just the discharge of the gun. And then my client could get DNA to prove he didn't do it. But the fact the robber didn't shoot Miss Wellman means he can't. That's a world of justice turned upside down as far as the defense is concerned. And we submit to you that that's a poor explanation to Jack LaPointe, whose earliest out date is in the mid-2030s in this case. Then, well, you just charged with wrong crime, Jack. Your Honors, we'd ask that this case be remanded. There is evidence of innocence here, certainly more than the George case, we'd argue. Would this case result in a different verdict from the jury? You bet. With the vouching out, which would happen, with the alibi put in a legitimate way, which, again, the Court of Appeals had strong problems with how the defense attorney denigrated his own alibi witness. with this hair evidence, with the mitochondrial DNA, I'd bet my law license that that verdict is not guilty. Thank you.
Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement. This time.